the same page as well. We don't have any drug court add-ons or anything, right?
I don't see anything. No.
Okay.
It's just gonna be a long arraignment day, that's it.
It is 9:03 a.m., March 22nd, 2021. We're ready to get started. If I can have the counsel for the parties put their appearance on the record.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Okay. What is this? Okay.
Sometimes I delete emails.
Hey, send man around the judge, gonna do him first. Judge want man first, send him around.
Should be easy.
Yep.
Some of the drug court people that don't make it on a Friday, back on the Monday, normally we do that, but that's good. I'll take it.
You know, if one shows up, I think we can wing it.
Yeah, exactly.
Please tell me your name. All right, so you have two cases here for arraignment, 21 CT 1929, 21 CT 1930. Counselor, your office represents him in both of those. They're both Division 81 cases. One is a no motor vehicle registration, and one is operating a motor vehicle without a valid driver's license.
Your Honor, can you, what is his name? I'm sorry?
It's Jermaine Mann,
Mann?
but the AKA is Chris Johnson.
Okay.
Oh,
So it's on the arraignments. It looks like Chris Johnson. So we can arraign him on those two.
So I didn't realize that was an AKA. So the offer I conveyed to defense state has no offer at this time.
I don't think it matters. He has a bunch of other stuff as well.
Okay.
We'll enter a plea of not guilty.
All right, Division 81.
The state's not making an offer. I understand, but the state's not making an offer to resolve it. There has to be an offer made to resolve it. The state's not making an offer.
I'll take guilty.
No, he has another case.
I just went without.
I was waiting for the clerk to tell us the Division 81 dates. Oh, she doesn't have the dates, so hold on, we'll come back to that. In case number 21
They're not making.
CT 2158, you're here charged with no valid driver's license and no motor vehicle registration. It looks like Judge Wish saw him yesterday for this and gave the state 24 hours to come up with additional information.
Wait, which case are we on here?
It's a reset from yesterday.
It's under Jermaine Mann, not Chris Johnson.
Yes, Your Honor. I believe she didn't find PC as to the motor vehicle registration. State was not able to obtain a sworn statement from the officer. I was only able to obtain an email from the officer, so at this time, state has no additional information.
What does the email say?
It's rather lengthy. It just goes through his motor vehicle registration and that he doesn't have any. But I wasn't able to obtain a sworn statement.
All right. So she did find probable cause as to the no valid driver's license.
Yes, as to everything else except for the no registration.
All right, and it looks like he's got 2 out-of-county warrants. Resisting without violence, providing false ID to law enforcement. So all of that was already dealt with yesterday?
Yes, Your Honor.
Okay. Then I'll release him on his own recognizance as to count 2, no motor vehicle registration.
Are you going to stay the bond as to the no valid?
Yes.
Okay.
And just a moment, sir. Did she appoint the public defender's office? I'll appoint them if she did not. She did. Yes, sir.
I just wanted to say, on the paper, I tried to tell the officer, I tried to take my mini bike to the place. On my paperwork is 49 cc's in the state of Florida. They would not.
Get really close to the microphone.
I would-
on the.
I would recommend you not talk about the facts of the case.
It's a citation.
Okay.
It's, on the paperwork, I try to tell the officer that the 49 cc's, they will not let me take my mini bike. It's for my kid. And it's 49 cc, it stays in my paperwork. And in the state of Florida, they will not let you put a 49 cc motor vehicle on and register it. That's why I didn't have it registered.
So I don't know about that, sir, but I do know that you can't drive a motor vehicle on the roads in Florida if it's not registered. So if you think you have a defense to this, you need to talk to your attorney about it. I appointed the public defender's office. Actually, Judge Wish did yesterday.
Is there any way I can resolve it? I'm trying to get to.
No, sir, the state doesn't have an offer for you today on all of your charges. Additionally, you have 2 out-of-county warrants,
In us.
which we cannot resolve today either. You have to go back to the county where they issued those warrants.
Yeah, I know that. I just want to get transported over there or whatever's going to happen. I just want to, with y'all, Orange County, I'll take guilty, whatever. I just want to get this done with so he can come get me, please. I have serious charges over there, that's why.
Does the state have an offer?
No, Your Honor, due to the name discrepancy, I didn't look up history, so this time I do not.
Wait, say that one more time. I couldn't hear you.
Due to the name discrepancy and it coming in as Chris Johnson, I did not prepare an offer for under his name. I prepared it under Chris Johnson, which was an alias. Therefore, the offer that I did prepare is not valid. And I didn't have time to look up his history to convey new offers. So at this time, I do not have an offer.
All right, so because of the false name because you gave a false name to the law enforcement officer, the state prepared an offer under the other name. So they don't have enough time right now to do the research under your real name to prepare an offer. So what you can do is talk to the public defender's office about getting a date set to change your plea as quickly as possible if that's still what you're interested in doing. Do you understand?
So I didn't,
You have to talk to your attorney about it.
All that number when you,
I don't have anybody.
all that number. You're not doing anything.
Good luck, sir.
You got it.
Okay. I don't have the next one. Did you guys take him for some reason? Aggravated, Torres. So we're not doing it right now, even though we're now at the beginning and that would be moving it up? No? Okay. So now we're doing Spanish?
Doing Spanish.
Oh my gosh.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Good morning, thank you. Could you please connect to the headset and ask if he can hear you?
Okay. There is contact, Your Honor.
Thank you. Please tell me your name, sir.
Pedro Aguilar Sanchez.
Pedro Froilan Andres Sanchez.
Sir, you're here in case number 21 CF 3316, charged with battery, domestic by strangulation, and domestic battery. I'm going to appoint the public defender's office to represent you. I reviewed the probable cause affidavit. I do find probable cause exists in this case. At this time, your bond will be $2,500 on count 1, $100 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You can't have electronic communication with her. You can't send a message through a friend or a family member. No contact at all. You understand?
Yes.
You're not allowed to possess a weapon of any kind, a firearm, or ammunition. Were you living at 5864 Diego Street?
Sí.
Yes.
All right, at this time, I'm going to order that you maintain a separate residence. I'll allow one-time return with law enforcement officers to gather your belongings, but you cannot contact her to gather your belongings. Do you understand?
Yes.
And you can't live there. You understand that? You have to live separate from her.
Okay.
Good luck, sir. There you go. Please tell me your name.
Henry Rivera Colon. Henry Rivera Colon.
Henry Rivera Colon.
You're here in case number 21 CF 3332AO, charged with kidnapping, false imprisonment, possession of cocaine, and battery. At this time, I'm going to appoint the Public Defender's Office to represent you. Counselor, did you wish to be heard?
Yes, Your Honor. I'm arguing no PC on the kidnapping. According to Florida statute 787.01, the term kidnapping means forcible, secretly, or by threat, confining, abducting, or imprisoning another person against his or her will, with the intent to hold for ransom or reward, or shield or hostage, commit or facilitate the commission of any felony, inflict bodily harm upon or to terrorize the victim of another person, or interfere with the performance of any governmental or political function. The Florida Supreme Court has adopted a three-pronged test on whether that confinement during the commission of another felony is sufficient. Understanding that if you recognizing that a literal construction of the kidnapping statute would potentially convert almost any forcible felony into kidnapping, that the court stated that for a kidnapping conviction, the resulting movement or confinement must not be slight, inconsequential, and merely incidental to any other offense. It must not be the kind inherent in nature of the other offenses. It must have some significant independent of the other offense, and that it makes the other offenses substantially easier to commit or substantially lessen the risk of detection. Here, the argument is that this is a domestic violence dispute. My client and the victim both reside in the same household. He merely brings her upstairs, sits her in the bathroom where the victim states the door was open. She states she was afraid to leave because she thought that he would hit her. However, the door was open. She never attempted to leave. And he then grabs her cell phone, searches through her cell phone, and then searches throughout clothes and shoes and cabinets. Here, Your Honor, we have false imprisonment. We have the battery. However, to find PC for a kidnapping in this situation where we have a domestic violence situation, there's nothing here based on the statute and the Supreme Court that would show that this is not incidental to the domestic violence dispute.
I'm sorry, Counselor, are you arguing that people in a relationship can't be kidnapped?
I'm arguing that it's incidental. The Supreme Court has ruled that it's incidental to the domestic violence. So you have the false imprisonment, you have the domestic violence. This does not rise to the level of kidnapping. They reside in the same household. He brings her into the bathroom where you have the false imprisonment because she's being held in the bathroom. The door's open. She states she's afraid to get up and try to leave. But just like the Supreme Court states that if we were to find every time that a person in the course of committing a crime, holding somebody against their will is a kidnapping, you would find any forcible felony to be a kidnapping. And in this case, I'm saying it doesn't rise to the level of a kidnapping.
What says the state?
Your Honor, given the facts of this case, he didn't just take her to the bathroom. He went outside, took her forcefully from the stairs back inside when she was trying to leave to get away from the argument. Then once inside, he forcefully took her again to the bathroom by grabbing her, she described it as her triceps, leaving bruises on her triceps. To prove kidnapping, the state only has to prove 3 elements: that the defendant forcibly, secretly, by threat, confined, abducted, or imprisoned. Here, the state would argue that he imprisoned her against her will. 2, that the defendant had no lawful authority to do so. He took her from outside into inside. He had no authority to do that. And he acted with the intent to inflict bodily harm upon her or terrorize another person, and during the commission of another felony. And in this case, it was the domestic violence. So here the state would argue that there is PC for the kidnapping, as he did move her twice. And the time that he moved her to the bathroom, when the door was open, she did have a fear that he would inflict bodily harm on her, and that is where the false imprisonment comes in. However, he did move her forcefully twice without her permission or authority to do so. And it was against her will, and she feared for her life.
And Your Honor, I would just argue that even in a case, Griffin v. State, where a 3-year-old was kidnapped during the course of a store robbery, where a defendant pointed a gun at a girl and held her in the bathroom in order for them to rob the store, the court held that wasn't sufficient enough for a kidnapping because it was in the course of the robbery and it was no more than necessary to commit that robbery. My argument is that it was no more than necessary to commit the battery and the false imprisonment. This wasn't a situation where it's a random person, he's kidnapping that person, or even if it wasn't a random person, if it's a situation where he grabs her, takes her into the house, there's nothing to say that he beat her. There's nothing to say that he told her she couldn't leave the bathroom. There's nothing in this case that will rise to the level of a kidnapping. If you read the facts of the case, you would see that the child was in the living room, and he forced her back into the bathroom because the child was in the living room. He sat him on the couch, and he moved her into the bathroom away from the child.
Right. Counselor, it sounds like to me from the facts of the case and what you're even arguing yourself, the police officers could have charged him with additional offenses, and the state still might charge him with additional offenses, because I don't see the child as a victim in the PC affidavit. But even by your own statement, he moved the child
He was already in the house, Your
against the
Honor.
child's will. Okay, but just because you live in the same house with someone doesn't mean they have the right to put their hands on you or to pick you up and drag you up the stairs and then forcibly keep you in a bedroom. I don't think familial relationships excuse criminal behavior.
Your Honor, that's not my argument. My argument is that it doesn't rise to the level of a kidnapping. Again, if all it takes is me to grab your arm and take you into the bathroom to be a kidnapping, then any forcible felony, again, just like the Supreme Court stated, would be a kidnapping. It will rise to the level of kidnapping.
In this instance, the victim tried to escape the residence. The defendant followed her out of the residence, down the stairs, forcibly picked her up by the arms, carried her back into a residence that she attempted to leave, according to the probable cause affidavit. I appreciate your argument, but this time I'm finding there is probable cause for all of the charges here that are in the probable cause affidavit. Sir, your bond will be none on count 1, $5,000 on count 2, $150 on count 3, $100 on count 4. You're not allowed to have any contact with the victim. Do you understand what no contact means? Sir, look at me. Do you understand what no contact means?
Sí.
You can't call her from the jail. You can't send a message through a friend or a family member. You can't contact her using social media. No contact at all. Do you understand?
Okay.
Okay.
I'll further order that at this time, you're not allowed to have any contact with any of the other witnesses in the case. I'll order you comply with any plan set in place by DCF. You're not allowed to possess or consume illegal substances. You're not allowed to possess a weapon of any kind, firearm or ammunition. I'll order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Okay.
Okay.
Good luck, sir.
Gracias.
Please tell me your name.
Juan Carlos Cofresi.
Juan Carlos Cofresi.
You're here because a warrant was issued for your arrest in 19 CT 154 for failing to appear on a charge of a driving while license suspended. The bond is $1,000. For no valid driver's license for a motorcycle, your bond is $1,000. No registration, your bond is $500. That's out of Osceola County. We'll notify them that you're here, but you do have that bond on those charges. In case number 19 CT 152, a warrant was issued for your arrest out of Osceola County. Oh, that's the no motorcycle endorsement that I already talked about. In 19 CT 151, that's the no registration. Your bond on that is the $500. In 19 CT 154, that's the driving while license suspended. That warrant has a $1,000 bond. In case number 52092, a warrant was issued for your arrest out of Polk County for possession of heroin, possession of cocaine, and possession of drug paraphernalia. Allegedly, you failed to appear. Your bond is $1,000 on count 1, $1,000 on count 2, $1,000 on count 3. We'll notify them that you're here so they can transport you. In case number 21 CT 2175, you're charged with driving while license suspended. In this case, I'll appoint the public defender's office to represent you. There is probable cause. Your bond will be $500. Good luck, sir. Please tell me your name.
Juan Miguel Sanchez.
Juan Miguel Díaz Sánchez.
Miguel Sánchez. Juan Santiago Miguel Sánchez.
Juan Santiago Milles Sánchez.
You're here in case number 20 CF 15211. A warrant was issued for your arrest for violating your conditions of pretrial release, in that you possessed or consumed illegal substances on February 24th. At this time, your bond is count 1, $900, count 2, $100. I'll appoint the public defender's office to represent you.
Your Honor, I have 3 counts on that.
I see 2 counts.
I have
Hold on.
1 as heroin, 2 as heroin with intent to sell or deliver,
You're right.
3 as drug paraphernalia.
All right, you're right. I do see that now, but I don't see a bond on count 3.
On 3, I have it as no bond, which wouldn't make sense for the paraphernalia.
Hold on. I'm trying to read the judge's handwriting. I have count 1, count 2, no count 3. It says possession of drug paraphernalia was not listed in original offense. IMS has been updated to reflect the correct information. So it's possible the judge who signed this warrant didn't have count 3. I'll make your bond $100 on count 3 as well.
Well, I don't have it.
The information only has 2 counts? This is possession of heroin.
All right.
So the judge signed a warrant with the charges listed: possession of heroin with intent to sell, and possession of drug paraphernalia. And then the state filed a charge, possession of fentanyl.
And controlled substance on the first. Yes, Your Honor.
What's count 1?
Count 1 is possession of fentanyl.
Where's the heroin?
I'm assuming the FDLE report came back and it was probably fentanyl instead of heroin. Or it was a mixture of maybe fentanyl and heroin, which is the reason for the controlled substance charge. I can look into it.
All right, so the state filed 2 charges?
Yeah, okay, so the FDLE report came back, it was fentanyl and xylazine, which is why there is a charge of fentanyl and possession of a controlled substance.
All right, so his bond will be $900 on count one, $100 on count two. There is no count three now. Good luck, sir. Good grief. Please tell me your name.
Michael Echevarría Torres.
Michael Echevarría Torres.
All right, you're here because a warrant was issued for your arrest out of Nassau County. The correct charges on that warrant are forgery, counterfeiting, altering, or simulating animal health requirement certificates, criminal use of personal identification information. The bond on each count is $2,502. And we'll notify them that you're here. Yes, sir.
Es que me trajeron a mí el viernes aquí y me pusieron un cargo por DUI y violation de probation. Y yo no tengo, cuando vine el sábado aquí no me dieron fianza por esos dos cargos. Y cuando fui para mi cuarto el domingo, fue un oficial ante mí y me dijo que ese cargo no era el mío, que ese cargo era un error de aquí, que me lo iban a quitar para yo poder tener fianza hoy por el otro cargo.
Well, the thing is that I was brought here Friday, and they told me I was here because of a DUI and a VOP. But those charges were not mine. They didn't give me a bond on Saturday because of this. But then on Sunday, an officer came to me and he told me that there has been a mistake and that I would receive a bond today.
Yes, sir, I just gave you bond.
Y el otro cargo se cayó ya, que yo pueda salir.
Were the other charges dropped? Will I be able to come out?
The VOP wasn't yours. It's a different individual for the VOP on a DUI. So that's not a charge against you at all. So your two charges out of Nassau County each carry a bond of $2,502. You have to post that bond to be released.
Lo que pregunto es
I'm
que
sorry?
presté a esa fianza, pero no me dejaron salir porque todavía parece como que tengo el hold del DUI.
I don't have an order on a
Ya
VOP.
pagué la fianza y dijeron que no me dejaron salir porque todavía sale en el sistema el otro cargo.
I already paid the bond, but they told me I wasn't allowed out yet because I still had the hold for the DUI.
No, the VOP DUI is a warrant for a different individual.
Pero cuando entré aquí y vine a la corte por primera vez el sábado, me dijeron que eso era mío y me hicieron un juicio por eso a mí. Sí, aquí el sábado y me dijeron no fianza por eso es que todavía aparece en el sistema.
This is not his charge.
Well, when I was here last Saturday, they held a hearing regarding that.
Yes, I understand. Then they found out it wasn't you. So now you have two charges. You have to post that bond, and then you'll be released.
Thank you.
Why?
After he came to Aggravated, Nassau County sent a correction, so the VOP, you have to have an order taken out of us.
All right. Yeah, because it's not his charge. All right, good luck, sir. Yeah, it should have never been his charge.
Thank you.
Yes, sir. I didn't do it. Someone else did it. Is that all the Spanish speakers?
Yes, Your Honor.
I think that's all we need from the interpreter this morning. Thank you.
Thank you, Your Honor.
Okay, we have one Creole. She's ready.
Is he the Creole?
Yes.
This is Judge Gibson. Can you hear me?
Very faintly.
No, she's not. That's weird. This is Judge Gibson. Can you hear me now?
Yes,
Could the interpreter please put your name on the record and whether you've previously been sworn today?
I have not been sworn. My name is Isabel DeRocher.
Please raise your right hand to be sworn.
Sure.
Do you swear to translate from Creole to English, English to Creole, the testimonies you will receive today?
I do.
Thank you. Sir, please tell me your name.
Monsieur Dimki Jean Relais.
Manis Joseph.
Pardon?
Manis Joseph.
Manis Joseph.
You're here in case number 21 CF 3326, charged with battery, felony battery.
Ou ici dans cas 21-3326 ou accusé de attaque sur monde.
I'm going to appoint the Public Defender's Office to represent you.
Ma beau défenseur public pour représenter vous.
There is probable cause for your arrest in this case.
Gen assez évidence pour yo te arrêté ou dans cas ça. Hello?
I'm looking.
Oh, I'm sorry.
That's okay. He doesn't qualify for pretrial release. Is it the charge? Okay. All right, your bond will be $2,500.
Gen on bond de $2,500.
You're not allowed to have any contact with the victim. Do you understand what no contact means?
Ou pas gen permission gen contact avec victime là? Est-ce que vous comprenez qui ça pas de contact vle di?
Oui.
Yes.
You can't call her on the phone. You can't send a message through a friend or family member. You can't talk to her using social media. No contact.
Ou pas capable rele dans téléphone, ou pas capable message avec un ami, ou pas capable contacter dans réseau social, tant que Facebook ou bien bagage comme ça, ou pas capable aucun contact du tout.
Oui.
Yes.
I'll order that you maintain a separate residence and allow a one-time return with law enforcement to gather your belongings.
Ou besoin rester dans l'autre taille, ou pas capable rester dans même taille avec victime là, m'a permettre de retourner une grande fois avec la police pour capable prendre affaire.
Oui.
Yes.
You're not allowed to possess a weapon of any kind, a firearm, or ammunition.
Ou pas capable gagner aucune arme, ou pas capable gagner arme à feu ou bien munitions.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Bonne chance, monsieur.
Thank you, Madam Interpreter.
You're very welcome. Have a good day.
You as well.
Bye-bye.
Please tell me your name.
Ashley Charles.
You're here in case number 21 CF 3330, charged with domestic battery by strangulation, criminal mischief, and battery. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Ma'am, do you wish to testify?
No.
All right.
Your Honor, I believe she qualifies for PTR.
I think so. I'm seeing that the answer is yes, but I'm just looking at the last conviction
History.
and the history, and I'm not inclined to do that unless the parties can give me a reason.
Not without input of the victim, Your Honor.
I'm sorry, what?
Said not without input from the victim.
She's fine. She can go on it.
Hold on. If you want to testify, we have to swear you in. Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Allison Norman.
Spell your last name, please.
Say it one more time.
Spell your last name.
Norman.
State you may inquire.
Good morning. Can you please state your relationship to Miss Charles?
A friend.
Okay. Are you afraid of her?
Yes.
Were drugs or alcohol involved in this?
No.
Has anything like this ever happened before between the two of you?
No.
And do you want to have contact with her?
Yeah.
And are you willing to call 911 if anything were to ever occur in the future?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No.
All right, Ms. George. It says she qualifies for pretrial release, but I still don't know that I'm inclined to do that. Can you give me some reasons?
The first reason is that the victim stated she has no objection to my client being released on pretrial release. My client is employed full-time. It looks like she's been there for 8 years. And I show the last conviction she has was resisting without violence in 2018, with only one failure to appear in 2011. Also, if she's placed on pretrial release, if anything happens, she'll be brought back here where she can be held at no bond.
What says the state?
Your Honor, the victim testified that she doesn't have any objection to Ms. Charles being on PTR. She did state that she was afraid of her. So if you are inclined to do PTR, we would just ask for a no contact.
All right, at this time, I'm going to place you on pretrial release. With special conditions, you're not allowed to have any contact with the victim. Do you understand what no contact means? I need you to get closer to the microphone.
Yes.
You can't have electronic communication, you can't call her on the phone or send a message through a friend. No contact.
Yes.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the Days Inn Hotel at 3300 South Orange Blossom Trail. You're not allowed to have any contact with any other witnesses in the case. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Thank you, ma'am.
Thanks.
Your Honor, next on the list is Garvin, Desmond, Medical.
Thank you. Case number 21 CF 3327. I'm going to appoint the Public Defender's Office to represent him.
We'll waive, Your Honor.
There's not a victim here, okay. There is probable cause in this case. His bond will be $1,000. No contact with the victim. Maintain separate residence. I'll allow one-time return with law enforcement to gather belongings. Cannot possess a weapon of any kind, firearm, or ammunition. All right, that's it. Please tell me your name, sir.
Patrick Jean.
You're here in 21 CF 3097. A warrant was issued for your arrest, charging you with domestic battery by strangulation. Another judge has already found probable cause in this case. I'll appoint the Public Defender's Office to represent you. Your bond will be $2,500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
No electronic communication. You can't call her on the phone. You can't send a message through a friend or a family member. No contact. You understand?
Yes.
You're not allowed to possess a weapon of any kind, firearm, or ammunition.
No.
Were you living together?
Yes.
All right, you can't now. I'm ordering that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you may not contact her to coordinate that visit. Do you understand?
Yes.
Are there any other conditions the state would request?
No, Your Honor.
Good luck.
No weapons.
Thought I said that. No weapons, no firearms, no ammunition. Good luck. Please tell me your name.
Rivera Jones.
In case number 21 CF 3313, you're here charged with aggravated battery. I'll appoint the Public Defender's Office to represent you. There is probable cause in this case. Your bond will be $2,500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
No electronic communication. You can't call on the phone or send a message through a friend or a family member. No contact at all. You're not allowed to possess a weapon of any kind, firearm or ammunition. I'll order that you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that visit with the victim. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Good luck. Please tell me your name. Adams. In case number 21MM115, you're here charged with battery. I'll appoint the public defender's office to represent you. There is probable cause. Sir, do you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Chad Dela Cruz.
Spell your last name, please.
DELA space CRUZ.
State you may inquire.
Good morning, sir. Can you please state your relationship to Miss Adams?
Girlfriend. Or I'm the boyfriend.
And how long have you known her?
I've known her about a year.
Are you afraid of her?
No.
Were drugs or alcohol involved in this incident?
Alcohol.
And has anything like this ever happened before between the two of you?
No.
Do you want to have contact with her?
Yes.
And if anything were to ever transpire between the two of you in the future, would you feel comfortable calling 911?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Why doesn't she qualify for pretrial release? All right, at this time, your bond will be $500. Based on the testimony here today, I'll allow you to have contact with the victim, but it must be peaceful, no hostile contact. Do you understand what that means? You can't even raise your voice. Did you answer me? Okay. While out on bond, you're not allowed to possess or consume alcoholic beverages. You're not allowed to possess a weapon of any kind, firearm or ammunition. I'll order that you two maintain a separate residence. I read that you are already doing that, so please continue to do that. Are there any other conditions the state would request?
No, Your Honor.
You live in Melbourne? All right, you can return to Melbourne when you bond out. Good luck. Thank you, sir.
All right, thank you.
Please tell me your name.
Eleanor Joy Brongan.
In case number 21MM1969, you're here charged with battery, domestic violence. I'll appoint the public defender's office to represent you. Sir, do you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and spell your last name, please.
Ryan Alexander Horton, Horton.
State you may inquire.
Good morning, sir. Can you please state your relationship to Miss Brongan?
That's my wife.
Are you afraid of her?
No.
I'm sorry, I couldn't hear you.
No, I'm not afraid. No.
Were drugs or alcohol involved in this incident?
No.
And has anything like this ever happened before between the two of you?
No.
Do you want to have contact with her if she were to get out of jail today?
Yes.
And if anything violent ever happened between the two of you in the future, would you be comfortable calling 911?
Of course.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
All right, ma'am, at this time, I'm going to place you on pretrial release with special conditions. Based on the testimony here today, I'll allow you to have peaceful contact with your husband. Do you understand what peaceful contact means?
Yes, ma'am.
You can't even raise your voice.
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm or ammunition. Based on your testimony, sir, I'll allow her to return back to the home.
Thank you.
Are there any other conditions the state would request?
No, Your Honor.
There is probable cause, and I'm appointing the public defender's office. Good luck, ma'am. Thank you, sir. Please tell me your name. You got to get closer to the microphone. In case number 21MM173AW, you're here charged with battery, domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case. I see that he qualifies for pretrial release. What says the state?
Your Honor, state has no objection as we don't have any victim statements from here today.
I'll place you on pretrial release at this time. With special conditions, you're not allowed to have any contact with the victim. Do you understand what no contact means? You can't call her on the phone or speak to her using an app on your phone. No contact at all. You're not allowed to possess a weapon of any kind, firearm or ammunition. Were you living together? Yes. You're not now. I'm going to order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that through her. Do you understand? Yes. All right, good luck. Please tell me your name.
Sheldon Felix.
In case number 21MM1976, you're here charged with battery, dating violence. I'll appoint the public defender's office to represent you. There is probable cause for your arrest. Ma'am, do you wish to testify?
Yes.
You have to leave your mask on. Just get close to the microphone and raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes.
Please state your name and spell your last name, please.
Okay. Simone Cummings, last name spelled Cummings.
State, you may inquire.
Good morning, Ms. Cummings. Can you please tell us your relationship to Mr. Felix?
Yes, that's my boyfriend of 4 years. We had a good relationship for the most part. This just happened, so
Okay.
I didn't want this whole thing to go on, but it happened, so, you know.
Okay. Are you afraid of him?
No,
Were drugs or alcohol involved in this incident?
no,
Has anything like this ever happened before?
no,
Do you want to have contact with the defendant?
yes,
And if anything were to ever happen in the future, would you feel comfortable calling 911?
yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Thank you.
I do believe he also qualifies for PTR.
I see that. At this time, I'm going to place you on pretrial release. With special conditions, you're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You can't call her on the phone or send a message through friends or family members. No contact at this time. You're not allowed to possess a weapon of any kind, firearm or ammunition. Were you two living together?
Yes.
All right. At this time, you're not going to be able to live together. I'm going to order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that visit through her. You understand?
Yes.
Yeah, okay. Yes, ma'am.
Is it possible if I can order us to be able to live in the same residence?
Wait, say that one more time.
I've never been through this, so is it possible if I can ask if we are able to live in the same residence?
It's possible, but I'm not inclined to do that, and I'll tell you why.
Okay.
In a situation like this, sometimes it's good for both parties to just have a little bit of time to breathe, some space from each other. So I think it's in everyone's best interest to just have a cooling off period at this time. But what will happen is he has an attorney who's representing him. That attorney can file a motion in front of the trial judge to change my order. So if another court changes that order and a judge signs an order that says you can have contact and he can move back in, then he'll be able to do that. Just not at this time.
Okay.
Good luck, sir. Thank you, ma'am.
Thank you.
Please tell me your name.
Purvis Grantham.
In case number 21MM1979, you're here charged with battery. I'll appoint the public defender's office to represent you. There is probable cause. Is there any objection to pretrial release?
No, Your Honor, as the victim is not present.
Sir, I'm going to place you on pretrial release at this time. With special conditions, you're not allowed to have any contact with the victim. Do you understand what that means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to possess or consume alcohol or illegal substances, and you'll be subject to random drug and alcohol screens. I'll order that you must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you can't coordinate that through the victim. You understand?
Well, we live in separate residence.
All right. So do you need to go back there for any reason?
No.
All right, then strike that. I'll order that he's not allowed to return for any reason. All right, good luck, sir. Oh, I did. Oh. Please tell me your name.
Israel Hepburn.
In case number 21MM1975, you're here charged with battery, domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case. Do you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes.
Please state your name for the record and spell your last name.
Tiffany Archie Hepburn, ARCHIE-HEPBURN.
State you may inquire.
Good morning. Can you please state your relationship to Mr. Hepburn?
My husband.
And are you afraid of him?
No.
Do you want to have contact with him?
Yes.
Were drugs or alcohol involved in this incident?
No.
Has anything like this ever happened before?
No.
If anything like this were to ever occur in the future, would you feel comfortable calling 911?
Absolutely.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
All right, at this time, I'm going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what no contact means? Hold on. Do you understand what no contact means?
Yes, I do.
You can't call her on the phone or send a message through a friend or family member. No contact at all. You understand? Yes, ma'am.
I really hope that you can try to change that because I have 4 kids from him and all his stuff is at the house and we do live together. We've been married for 10 years. This just actually happened. We're just going through a lot right now. I really don't need him to be away from me and the kids right now.
Ma'am, I understand what you're saying today, but I'm reading the probable cause affidavit where both of you stated previous incidents had happened. He showed a chipped front tooth to a law enforcement officer that he said reportedly happened because of you. It sounds like you have a pretty volatile relationship, and perhaps a cooling off period would be good for both of you and also your children. That's what concerns this court, and that's why I ordered no contact.
Okay.
Your Honor, we would just point to the fact that he has no criminal history. I don't see any arrests for domestic violence. And with my client being on pretrial release, if he was to return home and do anything, raise his voice, yell, or anything like that, and police were called, he would be brought back here and held at no bond. So we would just ask, based on the fact that the alleged victim wants contact, they have children together, they've been together for a long period of time, and he's employed full-time, and based on his criminal history, we would ask that you reconsider and allow them to have no hostile contact as opposed to separating the family.
So I show that he does have a criminal history, that his last conviction was for reckless driving. It was in 2008.
I'm talking about, Your Honor, domestic violence history.
I'm sorry, I thought you said he had no criminal history. Counselor, I already told you what my concern is. Did you read the probable cause affidavit where they both said things like this had happened before?
Yes, Your Honor.
Your client pointed to a chipped tooth, which he said was from a previous unreported incident. It just sounds like a really volatile relationship. The children were in the other room. Ma'am, I see you have a very small infant. Is that your child?
Yes.
Very volatile relationship, 4 children, very small infant in the home. That's this court's concern.
Well, we don't live here. We just moved here, so he doesn't have anywhere to go. That's the problem.
Where did you move from?
From Miami. We just moved here a couple months ago. So he doesn't have anywhere to go. And like she said, he has a very good job that we're trying to have him keep to take
Sir,
care
where
of
do
us
you
because
work?
I'm not working right now.
Hold on. Where do you work?
COVID testing site.
Wait, I'm sorry. Say that one more time.
COVID testing site.
Oh, at a COVID testing site. I'm sorry, I couldn't hear you. Oh, it says that. Do you want to go back to the home?
Yes. Yes, ma'am.
I'll tell you what I'm worried about.
Okay.
I'm looking at your even history of arrest. It's drug use, and you two have a volatile relationship. You can assure this court that if I let you go back to the home, none of this is going to happen again?
Yes, ma'am. It's not gonna happen again.
What says the state?
Your Honor, I'll leave it within your discretion.
You don't have to worry.
I'm sorry?
Say, you don't have to worry.
Apparently, she chipped your tooth. I'm really worried.
It was just arguing. I'm going through postpartum depression, and I don't know how to, both of us were just angry, and that's all that happened. But we've been together a long time, and I wouldn't have called the police unless I really know that I didn't want it to go any further. So it was just really just a cooling off period, but I'm so over that right now because I have to look at my husband and where we've been for 10 years. We just celebrated our 10-year anniversary on the 6th of March. So it's not like a 1-year relationship, and it's kind of hard because we just moved here. Even our license is from Hollywood, Florida. It's not from here. So.
All right. Against my better judgment, I'm going to change my order. I'm going to allow you to have peaceful contact with your wife. You understand that means you can't even raise your voice?
Yes, ma'am.
And this court has no jurisdiction over her, only over you. So if she raises her voice and you yell back, you're the one who can come back to jail. You understand that?
Yes, ma'am.
I will allow you to return to the residence. You're not allowed to possess or consume alcoholic beverages or illegal substances. You'll be subject to random drug and alcohol screens. You're still not allowed to possess a weapon of any kind, firearm, or ammunition. It sounds like you have a lot going on. Maybe try and get some help for that, because if you come back, you won't be getting back out. You understand that?
Yes, ma'am.
Yes.
And this is what you want, ma'am.
Yes, we're getting counseling. We are going to counseling.
Listen, I understand life happens. Lots of stress is happening for lots of people right now, so I understand that, but it can't turn criminal, you understand?
Yes, ma'am.
Yes, ma'am.
All right, good luck, sir. Thank you, ma'am.
Thank you.
Your Honor, Mr. Monk's behavior.
Thank you. Case number 21 MM 1971. Counselor, he's here for a battery charge.
Will waive, Your Honor.
I'll appoint the public defender's office. There is probable cause. His bond on that will be $500. No victim contact, not returned to the, does anyone know the hotel name?
Here,
He
you
has
have
a victim also.
All right, thank you. The Catarina Hotel, located at 830 Lee Road, Orlando, Florida. Yes, I think.
One second, Your Honor.
Not possess a weapon of any kind, firearm or ammunition. Ma'am, do you wish to testify? You have to leave your mask on.
I don't really know what you mean by testify, but no, I'm not trying to like press charges or anything.
No, if you want to be heard, if you want to speak to the
Yes.
court today, you have to be sworn in. So raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and spell your last name.
Christine Moore, Moore.
State you may inquire.
Good morning. Can you please state your relationship to Mr. Monk?
I'm his wife.
Are you afraid of him?
No, I am not.
Has anything like this ever happened before?
Yes, it has. He has psychosis. I guess he's not here for his behavior. But he needs help. I think he needs like drug rehab or something. But about almost a year ago, he got into an accident where he overdosed, and ever since then his mind hasn't been right. So I don't think that he deserves jail, but he needs help.
Were drugs or alcohol involved in this incident?
Yes.
One or both?
Both. No, I'm sorry, no alcohol.
Just drugs?
Yeah.
And if you were to get out of jail, would you want to have contact with him?
That's my husband. I love him to death. I just want to get help for him.
Okay. And if anything were to ever happen between you two in the future that was violent, would you be willing to call 911 again?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
All right. Ma'am, I understand your testimony today. I appreciate you coming. At this time, I'm still going to order him not to have contact with you.
No, that's perfectly fine.
Okay.
His mom wants them to come home, and I want him to go to his mom's house.
All right, so I'll order him to maintain a separate residence, and I'll allow him one-time return to your place to gather his belongings with law enforcement. He's not allowed to possess a weapon of any kind, firearm or ammunition, or any illegal drugs. But ma'am, he's out on bond right now in a battery case,
Yeah, I know.
21 MM 550. At this time, I'm revoking his bond in that case,
Okay.
so he's not getting out of jail right now.
Okay, so, what exactly is gonna happen to him?
You can't tell him that, because he's not allowed to have contact with you.
No, I'm saying exactly what is gonna happen to him. That's what
I'm sorry. I thought you said, when could you tell him? So what will happen is his attorney will file a motion in front of the trial court to get his bond changed. But at this time, because he's out on bond for a battery and committed a new battery, I'm revoking that bond.
I kind of wanted that to happen, but I don't think he deserves jail. If you guys can get him some mental health help, like drug court or something.
He doesn't qualify for mental health pretrial release. Oh, and I'm not going to revoke on the trespass case. But make sure that you tell his attorney that when you speak with his attorney, okay?
How do I know to get a hold of his attorney?
Hold on. Give me 1 second. I'm not going to revoke in 21 MM 934. Call the public defender's office. I don't know how long it takes the paperwork to get through in their office for them to assign an attorney. I imagine he won't have one today. Is that right, Ms. George?
Yes, Your Honor.
It'll probably take a few days for him to get an attorney assigned to his case. So, but that's who you want to talk to, is the public defender's office for his attorney. And then if you want to talk, the state of Florida is who's prosecuting him. So you can also call the state attorney's office because you're the victim in the case, and they'll be reaching out to you as well.
Okay.
All right. Good luck, ma'am. Thank you for coming. Who's next? Okay.
Yeah,
All ready?
Mr. Rodriguez is mental health.
21 MM 116, battery domestic violence. Counselor, I'm going to appoint your office to represent him.
Will waive, Your Honor.
All right. There is probable cause in this case. So let's screen him for mental health pretrial release, but if he doesn't qualify, then his bond will be $500. No contact with the victim, no weapons of any kind, firearm or ammunition. He's not allowed to return to the scene. Well, I'll do a one-time return with law enforcement, but maintain separate residence. No alcohol, random screens.
It was 500 if he doesn't qualify?
Yes. Please tell me your name.
Darius Lamar Simpson.
In case number 21 MM 1970, you're here charged with battery, domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
No electronic communication. You can't contact through friends or family member, nothing. You're not allowed to possess a weapon of any kind, firearm or ammunition. I'll order that you must comply with any plan by DCF. Were you living together?
Yes, ma'am.
You can't at this time. I'll order that you maintain a separate residence. You'll have a one-time return with law enforcement to gather your belongings. No alcohol. You're not allowed to possess or consume alcohol, and you'll be subject to random alcohol screens. Is there anything else the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name. In case number 21 CT 2176, you're here charged with driving while license suspended. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $500. You're not allowed to drive without a valid license. You understand that?
Yes,
The state has made an offer of an adjudication of guilt, credit time served, to which Mr. Lowe would like to accept. He understands all the rights he would be giving up.
Thank you,
He accepts
Counselor.
the state's offer.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Your attorneys just told the court that you'd like to enter a plea today, is that correct? And you understand the rights you're giving up by entering this plea? And you understand that driving while license suspended is what we call an enhanceable offense. After so many convictions, the state can charge you as a felon. You understand it becomes a felony at some point. And you still want to plead to this? Do you have any questions for the court about the rights you're giving up? At this time, how do you wish to plead to the charge of driving while license suspended? I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for, can somebody tell me how many days?
2 days, Your Honor.
2 days in jail. I'll have to order that you pay court costs. I'll give you a year to pay them. Good luck, sir. Please tell me your name.
Bilal Qureshi.
In case number 21 CT 465, you're here charged with driving under the influence. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $500. You're not allowed to possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. You understand that? I show him out on bond in case number 20 CT 130, which is also a DUI charge. At this time, I'm revoking your bond on that case. Good luck.
Your Honor, we would ask that you increase the bond amount, only because if you look, my client is employed full-time. He doesn't have any criminal convictions in Florida besides the DUI case. And because it's a nonviolent offense, we would just ask that you increase his out on bond charge, if possible, as opposed to setting him at no bond.
Thank you, Counselor. I'm not inclined to do that. He's out on bond for a DUI and arrested for another DUI. Also, you're not allowed to possess or consume illegal substances, and you'll be subject to random drug screens as well. Good luck, sir. Is that one? I added random drug screen too. The DUI, yes. No, not the out on bond, to the new DUI.
Oh, yeah, I got, you said that.
I said that, okay. Please tell me your name.
Christian Giovanni Velasco Lopez.
I'm sorry, one more time.
Christian Giovanni Velasco Lopez.
In case number 21 CT 692, a capias was issued for your arrest for failing to appear for arraignment on a charge of operating a motor vehicle without a valid driver's license. Your bond is $2,000. Does the state have an offer?
Yes, Your Honor, with whole credit time served.
Did you have a chance to talk to him about that, Ms. George?
I did, however, Your Honor, he's not an American citizen, so I recommended he not accept the offer until he speaks with the immigration attorney. However, I gave him the option to sit and think about it. I don't know if he wanted to accept it or wait.
Sir, do you want to enter a plea of not guilty today, guilty, or no contest?
I want to resolve today.
You understand if you're not a United States citizen and you enter a plea of guilty or no contest, you could be deported.
Yes.
And you still want to do that?
I don't want the poor.
I don't control ICE. So if you enter a plea today, they can deport you.
If I is a pay like 2,000, like
Your bond is $2,000. So if you're able to post that bond, you can talk to a bondsman about that.
is I pay the bond, like
You'll be released from jail if you pay the bond. The case is still pending, however. You'll have to come back to court to answer for the charges. So is that what you want to do? All right, good luck, sir. Do you guys have arraignments next?
Yes.
Okay. Please tell me your name.
Charles Gordon.
21 CT 709. operating a motor vehicle without a valid driver's license. I'll appoint the public defender's office.
I'm not sure if it's the case that I'm in on, and I'm kind of confused right now because I'm still confused from my arrest, but I'm not sure if this is even the case that I'm in on right now.
So the case that you're being arraigned on today is operating a motor vehicle without a valid driver's license. That's not his name.
Yeah. Can I see a
No.
arrest form or something? I don't even know when, how this
Gordon
happened.
Charles.
Because of that, then we'll enter a plea of not guilty.
So we're not addressing your other cases today. It's just this no motor vehicle registration. I mean, operating a motor vehicle without a valid driver's license.
Your Honor, we're going to enter a plea of not guilty.
All right. Division 81.
Division 81, pretrial conference date will be April 16th, 9 a.m., courtroom 4E.
Was this a new charge
Yes.
that came today?
I don't know when. I don't have a probable cause affidavit. It looks like you failed to appear on this charge at some point in the past, but I don't have the dates. You'll have to talk to your attorney about it.
Your Honor, I have the ticket. It looks like it was January 12th at 5:58 p.m.
What time, ma'am?
6 p.m.
6 p.m.? And there's a failure to appear on it?
No, that is when you picked up the no valid driver's license.
There's no failure to appear on it, right?
Failure to appear on February 9th, 2021.
So the ticket is in January. You had a court date in February, for which you failed to appear. But that's the charge.
So it's not the driver with no license that I'm in on now. It's a new one.
I don't know about that other charge. I only have this charge in front of me today. Ms. George, do you have all of his cases? Can you tell him?
We don't. I only have this one, Your Honor.
But does he have other cases?
Yeah, I only have this one.
All right. Apparently you have several other cases, but we're not addressing those today.
Can I close it today?
No. I don't even know what the other cases are. So you'll have to be in touch with your attorney about it.
Can I close the FTA today? Is there on the ticket? Plea?
There,
I don't know if the state has an offer.
Yes, Your Honor, it was an adjudication credit, I'm sorry.
So you can enter a plea to that charge, which is the operating a motor vehicle without a valid driver's license.
yeah, that's the only one we represented on. I don't see the other cases.
He has 19 other counts that he's currently in on.
What are they?
To the jail website, multiple charges of possession of firearm by a convicted felon and multiple charges of possession of ammunition by a convicted felon.
All right. So those are what are keeping you in custody, sir.
It's not, but this isn't.
That's gonna be another bond on top.
Do you want to accept the state's offer of adjudication of guilt credit time, sir? Your Honor, he would like to accept the state's offer of an adjudication of guilt credit time, sir.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
All right, sir, you understand that you have several other cases that are holding you in custody today.
Yes,
So if you enter a plea to this charge today, you'll not be released.
I know that.
All right.
I just wanna know, is this the case that I came in on, or is this a new case?
I don't know.
They arrested me for failure to appear for a driver's license. Is this the same one? Yes, ma'am?
So do you want to enter a plea of guilty or no contest to this?
Yes, I want to enter a plea.
And you understand the rights that you're giving up by entering this plea?
Yes,
You understand that if you're not a United States citizen, this plea could subject you to deportation?
yes,
You understand that if you're on probation, this plea could violate that probation?
yes.
At this time, how do you wish to plead to the charge of operating a motor vehicle without a valid driver's license?
I just want y'all to have the
No
right
contest.
So I can't keep getting these failure to appears because the court is sending notices to Miami and not to my new address in Orlando. That's why I keep getting these failure to appears.
All right, so how do you wish to plead to this charge?
Guilty.
I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll adjudicate you guilty. Give you credit for how many days? 6. I have to order that you pay court costs in this offense. I'll give you a year to pay them.
I'm disabled, man.
What's the address that you want the clerk of courts to send information to you?
714 Jernigan Avenue, Orlando, Florida, 32805. I'm disabled, ma'am. I receive a disability check every month that covers my bills and my medication.
All right, we'll update that in the clerk system for what that's worth. All right, good luck, sir.
Thank you.
What happened to Black?
Black was medical, Your Honor.
He's medical, 21 CT 1865, 21 CT 1866. Your office represents him, counselor.
We'll waive and enter plea of not guilty.
Division 63.
Division 63, pretrial conference date will be April 8th at 1 p.m., courtroom 12C.
Please tell me your name.
Timothy Clark.
What's your name?
Timothy Clark, Jr.
21 CT 313. You're here charged with driving while license suspended. Counselor, you represent him.
We're gonna enter plea of not guilty.
All right, Division 83.
Division 83, pretrial conference, May 12th at 1 p.m., courtroom 6C.
Health Division 83, correct? Thank you.
All right, good luck, sir.
Yep.
Your Honor, Mr. Mann is seen on the arraignment page.
I'm sorry, what?
Mr. Mann, the next client.
I don't have
is
him.
seen. Okay.
Okay. Please tell me your name.
Joshua Casado.
21 1867. He's represented by your office, counselor.
We'll enter plea of not guilty.
Division 84.
Division 84, pretrial conference will be April 12th at 9 a.m., courtroom 4B.
All right, good luck, sir.
Ms. Myers is medical.
21 1355. You represent her, counselor.
We'll waive and enter plea of not guilty.
Division 85.
Division 85, pretrial conference will be April 12th, 9 a.m., courtroom 4A.
Please tell me your name.
Lionel Wilkerson.
21 1420. You represent him, counselor.
Yes, Your Honor. Just a moment. So, Your Honor, the state is making an offer on the trespass of an adjudication of guilt, credit time served and no return. It just says 1414 22nd Street.
It's an abandoned building.
Oh, okay. He's gonna enter plea of no contest.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You can put it down now. You heard your attorney just tell the court that you want to enter a plea today. Is that correct?
Yes, ma'am.
And you understand the rights you're giving up by entering this plea?
Yes, ma'am.
Do you have any questions for the court about those rights?
No, ma'am.
You understand if you're on probation, this plea could violate that probation.
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation.
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of trespass?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 25, oh, it's right there, 25 days in jail. Sir, I have to order that you pay court costs. Do you have a job?
No, ma'am. I'm retired, ma'am.
Do you have a home?
I have somewhere to live, ma'am.
Okay. I'm gonna make it a lien. Sir, you can't return to, give me the address one more time.
1414 22nd Street.
You understand that?
Yes, ma'am.
All right, good luck, sir.
Thank you,
You
ma'am.
have 30 days to appeal in writing.
Thank you, ma'am.
Ralphie Quiles Colazo? Where's he? We skipped him.
He's surety bond, Your Honor.
All right.
On.
Jimmy Williams,
Medical, Your Honor.
20 MM 222. Counselor, you represent him.
We'll waive and enter a plea of not guilty.
Division 85.
Division 85, pretrial conference date will be April 12th, 9 a.m., courtroom 4A.
All right, let's take a brief recess, and then we'll jump back in and do 33-day motions and afternoon docket. How's that? About 10 minutes, does that work for everyone?
Yes, Your Honor.
All right, court will be in recess.
So we'll go ahead and set it for a plea on March 29th, 329. At 8:30 a.m. Thank you, Your Honor. May I stand down? Yes, thank you. Have a good day. Do you have any other cases on the docket? I do not. Okay, thank you.
All right, we are back on the record. It's 10:37. Let's do the 33-day motions. Starting with Johnson, 20 CF 14418.
Notice of non-filing.
And also Johnson, 21 CF 1686.
Notice of non-filing.
All right. Strong, 21 CF 1862.
Filed on the 16th.
Kinsey, 21 CF 2092.
Notice of non-filing.
Kinsey, 21 CF 1841.
Notice of non-filing.
Kinsey, 21 MM 1086.
Notice of non-filing.
Clark, 21 CF 2022.
It was filed on the, or notice of non-filing.
I need a new order because I checked denied when you said that and then you changed it.
Can you send it to me? Letitia?
All right.
Oh, sorry.
Fine.
I just changed it. The clerk said that'll work, so we'll see. Kinsey, 21 CF 2091.
Notice of non-filing.
Clark, 21 CF 621.
It was filed this morning.
'21 CF 797, Luches.
Filed on the 19th.
Arsenis, 21 CF 1586.
Notice of non-filing.
Henderson, 21 CF 1974.
Notice of non-filing.
Heron, 21 CF 617.
Notice and on filing.
Then I have Alonza Smith,
Yes, Your Honor, notice and on filing.
21 CF 1971. On a charge of first-degree murder with a firearm, the state filed a notice of non-filing.
Yes, Your Honor, I double-checked it this morning.
Whose case is this?
It was Dave Fierce.
Robert Huddleston. Then I have Quentin Willis, 21 CF 1975.
Notice and on filing.
All right. Everybody ready to get started?
Yes.
It'll help if I have them. Please tell me your name. You're here in 21 MM 1978, charged with retail petty theft. Hold on one second. I didn't see this one prior to court. Was it in this deck? All right, give me a minute. I have to read this. There is probable cause. I'll appoint the public defender's office to represent you.
Your Honor, the state conveyed an offer of a withhold credit time served, no return. I don't believe Ms. Alvarado has any history. However, I also told defense that she may qualify for PTD.
Yes. We're not gonna accept the offer. We're gonna ask for a ROR, Your Honor.
State has no objection to an ROR, given she has no history.
All right, at this time, I'm going to release you on your own recognizance. With special conditions, you're not allowed to return to Walmart or have contact with any of the witnesses in the case. Do you understand? All right, good luck. Please tell me your name.
Larry Eugene Jones.
21 MM 1973, you're here charged with possession of drug paraphernalia. Does the state wish to be heard?
Yes, Your Honor, state filed a no information this morning. May I first report?
Yes. The state's dropped the charges against you in this case. So based on that, I'll take no action on your out on bond case at this time. Sir, I show that you're a sex offender, which means you must maintain your sex offender reporting requirements. You understand that?
I never was on the register for a sex offender. When I committed that during the years, that law wasn't passed. I committed that before they passed those laws.
So you don't have to register?
No, I don't.
All right, good luck, sir. Please tell me your name.
Cameron Daniel Marino.
In 21 MM 171, you're here charged with loitering or prowling. I'll appoint the public defender's office to represent you. Do you wish to be heard, Ms. George?
Yes, Your Honor. We're arguing no PC on the loitering, prowling. In order to have a loitering or prowling, it states the statute 856.021. It's unlawful for any person to loiter or prowl in a place, at a time, or in a manner not usual for law-abiding individuals, under circumstances that warrant a justifiable, reasonable alarm or immediate concern for the safety of persons or property in the vicinity. And the statute also states when considering these things, you look to see if an alleged defendant runs, has an opportunity, when they see the police, they run away. And in this case, we have none of that. We have my client walking through a neighborhood where he says he was going to a friend's house. The friend wasn't allowed to have company, so he's leaving. He came into contact with multiple officers at first who did not arrest him. So as he's leaving, this police officer pulls up and asks him what he was doing, which he told him. He didn't run, he put his hands up. The only thing that he's guilty of is walking in a neighborhood in all black. And we would just argue that there's no PC for loitering or prowling.
What says the state?
Your Honor, for loitering and prowling, state just has to prove two things. One, that he loitered or prowled in a place at a time or in a manner not usual for law-abiding citizens. As to that, state would point to it was 1 a.m. in a neighborhood he did not live in all black clothing. And the caller said that he was acting suspiciously and walking around looking at vehicles and houses. And two, that the behavior occurred under circumstances that warranted justified and reasonable alarm or immediate concern of the safety of persons or property in the accused vicinity. The caller did say that this was reason for concern and safety as it was 1 a.m. and due to the clothing of the defendant, and given that he was looking at houses and cars and just kind of walking around aimlessly. And the officer must give a reasonable option for the defendant to dispel his concerns. The officer did say, I talked to him, learned about his story, and it was not dispelling his concerns. For those reasons, the state would argue that there is PC in this case.
Your Honor, we would just point to the fact that it's not a crime to walk around a neighborhood in all black. And if you look at my client's age, he's 19. When you're 19, it's not unnormal for you to go to someone's house at 1 a.m. This is a young kid. And he did nothing other than walk to his friend's house, and he was leaving when the officer approached him.
So, Counselor, I was leaning toward your argument being compelling until the state pointed me back to the very top of the probable cause affidavit. So the call that came in said that he was acting suspiciously and walking around looking at houses and vehicles. So I think combining that with the all-black clothing, that's the probable cause for loitering and prowling. However thin it might be, I think there's sufficient probable cause. However, does the state wish to be heard on bond?
State has no objection to an ROR.
I'm gonna release you on your own recognizance, but sir, you can't go back to Daniel's Crossing. You don't live there, right?
Yes, ma'am.
Okay, so you can't go back there while this case is pending or have contact with any of the witnesses in the case. You understand? Good luck. Please tell me your name.
Alan Slider.
Case number 21MM1972AO. You're here charged with defrauding an operator of a food or lodging establishment. I'll appoint the public defender's office to represent you. I do find there's probable cause in this case. Your bond will be $250. You're not allowed to return to. Does anyone know the name of the establishment?
1 second, Your Honor.
Uh, 7451 International Drive. You can't go back there, you understand?
Yes, ma'am.
All right, good luck, sir.
Punjab Indian Restaurant.
There you go. Don't go back there, okay? Good luck. Come on up, sir, and tell me your name.
Hey, Karos.
You're here in 21MO355, charged with an open container of an alcoholic beverage. Does the state have an offer?
Yes, Your Honor, withhold credit time served.
Are you interested in accepting the state's offer today?
Yes, I am.
There is probable cause in this case. Raise your right hand, please, to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
You understand the rights you're giving up if you enter a plea to this charge today?
Yes, I do.
Do you have any questions for the court about those rights?
No.
You understand if you're on probation, this plea could violate that probation?
Yes, I do know that.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes.
All right, at this time, how do you wish to plead to the charge of open container of an alcoholic beverage?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for
2 days.
2 days in jail. I have to order you to pay court costs. I'll give you a year to pay them. Good luck, sir.
Okay.
Please tell me your name. I'm sorry, I can't hear you. You have to get closer to the microphone. You have to leave the mask on, though.
Akram Ahmed.
All right, you're here in 21 CF 3325, charged with providing a false identification to a law enforcement officer, driving while license revoked, and trafficking in methamphetamines. I'm going to appoint the public defender's office to represent you, sir. There is probable cause in this case. Your bond will be $100 on count 1, $100 on count 2, and $50,000 on count 3. You're not allowed to possess or consume illegal substances. You can't drive without a valid Florida driver's license. You're not allowed to have any contact with known drug dealers. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Please tell me your name. Sir, in case number 20MM4558, a warrant was issued, a capias was issued for your arrest for failing to appear to a plea hearing on a violation of an injunction for protection against stalking or cyber stalking. I'll appoint the public defender's office to represent you. Your bond on that is $2,000. In case number 20 CF 6846, a capias was issued for your arrest for failing to appear on a status hearing on a charge of petty theft with 2 prior convictions. There's no bond authorized on that capias, and I'll appoint the public defender's office to represent you. In case number 21 CF 3323, you're charged with tampering with physical evidence, possession of drug paraphernalia, and providing false identification to a law enforcement officer. I'll appoint the public defender's office to represent you in this case. Sir, I do find there's probable cause here. Your bond in this case will be $1,000 on count 1, $100 on count 2, and $100 on count 3. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand? All right, good luck, sir. Please tell me your name. In case number 19 CF 7441, a capias was issued for your arrest for failing to appear for pretrial and motion to dismiss on March 8th on a charge of aggravated battery with a deadly weapon or causing great bodily harm. There's no bond authorized on that capias, and I'll appoint the public defender's office to represent you. Good luck, sir.
Your Honor, Keith Joyner is mental health.
Thank you. 21 CF 3329. Counsel, I'm going to appoint your office to represent him.
Will waive.
It's a possession of cocaine. There is probable cause in this case. His bond is $1,000. He's not allowed to possess or consume illegal substances or have contact with known drug dealers. Please tell me your name.
Jason Lidecker.
In 20 CF 45159, a warrant was issued for your arrest out of Brevard County for violation of probation on a possession of a controlled substance charge. There is no bond authorized on that capias. I'll appoint the public defender's office to represent you, and we'll contact Brevard County and let them know that you're here. In 21 CF 3318, you're charged with possession of fentanyl, possession of drug paraphernalia, and resisting an officer without violence. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $1,000 on count 1, $100 on count 2, $100 on count 3. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand? Good luck, sir. Please tell me your name.
Maria Pernisi.
In case number 21 CF 3319, You're charged with possession of drug paraphernalia, possession of heroin, possession of Xanax, possession of methamphetamine, and possession of cannabis under 20 grams. I'll appoint the public defender's office to represent you. Ma'am, I reviewed the probable cause affidavit. There is probable cause in this case. Your bond will be $100 on count 1, $1,000 on count 2, $150 on count 3, $150 on count 4, and $100 on count 5. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand?
Yes.
Good luck, ma'am.
Thank you.
Please tell me your name. I'm sorry, can you tell me one more time? In case 21 CF 3328, you're here charged with possession of cocaine. There is probable cause in this case. I'll appoint the public defender's office to represent you. Your bond will be $1,000. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand? Good luck, sir. Please tell me your name.
Jordan Smart.
In case number 21 CF 3314, you're here charged with carrying a concealed firearm, possession of methamphetamine with a weapon, possession of methamphetamine, possession of cannabis over 20 grams, and possession of cannabis under 20 grams. I'm going to appoint the public defender's office to represent you. Hold on one moment. There is probable cause in this case. Your bond will be $7,000 on count 1, $5,000 on count 2, $150 on count 3, $150 on count 4, and $100 on count 5. You're not allowed to possess or consume illegal substances. You're not allowed to possess a firearm or ammunition, and you're also not allowed to have contact with any known drug dealers. Do you understand?
Yes, I do.
You're also not allowed to have contact with the co-defendant in this case. You understand?
Yes.
Good luck, sir. Please tell me your name.
Your Honor, Mr. Tran is in the hospital.
Should we see him tomorrow, or should we continue with the IA?
We'll waive, Your Honor.
All right, I'll appoint the public defender's office. It's 21 CF 3333. He's charged with aggravated battery with a weapon. There is probable cause. Another judge has already found it in the warrant. His bond is $100,000. He's not allowed to have any contact with the victim. He's not allowed to return to the scene. He's not allowed to possess a weapon of any kind, a firearm, or ammunition. Please tell me your name.
Antonio White.
All right, sir. In case number 21 CF 3334, a warrant was issued for your arrest for grand theft and resisting a merchant. Another judge has already found probable cause. Your bond is $2,500 on count 1, $150 on count 2. You're not allowed to return to the scene or have contact with any victims, witnesses, or co-defendants. Do you understand?
Yes, ma'am.
All right, in case number 21 CF 3046, you're charged with burglary of an occupied structure and petty theft. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $2,500 on count 1 and $100 on count 2. You're not allowed to have any contact with the victims or any witnesses in the case, and you're not allowed to return to the scene. Do you understand?
Yes, ma'am.
In 21 MM 1980, I'm going to appoint the public defender's office to represent you. You're charged with petty theft. There is probable cause. You're not allowed to return to the scene of that crime either. Do you understand, sir? All right, good luck.
Are you staying the bond?
Oh, yeah, that bond is $250.
Is there any way I get a bond reduction, because I don't have that much money?
I can't at this time, but your attorney can file a motion in front of the trial judge who's hearing all of your cases, and that judge might reduce your bond based on your attorney's motion. Yes, sir. Please tell me your name.
Tyler Work.
In case number 21 CF 3320, you're here charged with possession of methamphetamine, possession of heroin, and possession of drug paraphernalia. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $1,000 on count 1, $150 on count 2, and $100 on count 3. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. Do you understand?
Yes.
In 21 CF 3321, you're charged with burglary of a dwelling and grand theft from a dwelling. I'll appoint the public defender's office to represent you in this case as well. I do find probable cause exists. Your bond will be $5,000 on count 1, $150 on count 2. You're not allowed to return to the scene for any reason. Do you understand?
Yes.
You're not allowed to have any contact with any victim or witnesses in the case. Do you understand what no contact means?
Yes, ma'am.
Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Can I ask you about downward departure or anything about that?
So I'm not sentencing you today for anything. What you'll want to do is talk to your attorney about that. So a downward departure means at sentencing, instead of being convicted of a certain crime, the judge could downward depart and sentence you to another. But today I'm not sentencing you. That's not happening in this court. So you need to talk to your attorney about it, and they'll talk to the state attorney's office about what they're charging. But that's what a downward departure means. All right, good luck, sir.
Your Honor, Ms. Wright just bonded.
Okay. Please tell me your name.
Alberto Colón Díaz.
In case number 21 CF 3335, you're charged with possession of cocaine with intent to sell or deliver, sale or delivery of fentanyl, possession of cocaine, possession of alprazolam, possession of fentanyl, and possession of drug paraphernalia. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $15,000 on count 1, $15,000 on count 2, $150 on counts 3, 4, and 5, and $100 on count 6. You're not allowed to possess or consume illegal substances or have contact with any known drug dealers. Do you understand? You have to answer out loud.
Yes.
All right. In 18 CF 3622, you're here for a violation of probation. There's no bond authorized on that, and I'll appoint the public defender's office to represent you. Good luck, sir. On count 2, yes. I did. Please tell me your name.
Adam?
Adam what?
Noel?
You're here because a warrant was issued for your arrest in case number 20 CF 10715 for violating your probation in that you failed to report to your probation officer as directed and you changed your residence without first procuring the permission of your probation officer. There is no bond on that warrant. I'll appoint the public defender's office to represent you.
I didn't change my address because I never had an address to change to.
Sir, I can't change this warrant. It's from another judge, so you'll have to talk to your attorney. We're not done. You have another case. 21 MO 356. You're here charged with indecent conduct. I'm going to appoint the public defender's office to represent you in that case as well. There is probable cause. Your bond will be $500. Good luck, sir. Please tell me your name.
Jose Luis Alberto Vargas.
In Case number 18 CF 9527, a capias was issued for your arrest for failing to appear on a VOP for a possession of cannabis charge. There is no bond authorized on that capias. I'll appoint the Public Defender's Office to represent you. In 2017 CF 4965, you're here for a violation of probation. There's no bond authorized on that, and I'll appoint the Public Defender's Office to represent you. The allegation is that you failed to comply with all instructions given to you by the probation officer. And in #21 CF 3304, you're here charged with possession of firearm by a convicted felon, possession of cannabis under 20 grams, possession of ammunition by a convicted felon. I'll appoint the Public Defender's Office to represent you in this case. There is probable cause. Your bond will be $5,000 on count 1, $100 on count 2, $150 on count 3. You're not allowed to possess a weapon of any kind, firearm or ammunition. Do you understand?
Yes, ma'am.
And I think there's one more. Did I miss one?
Yes, Your Honor.
18 CF 9527. Did I get that one? No, I did that one.
So I only have one, no bond, just one VOP, or?
9527 is no bond. And 174965 is no bond. You have two that are no bond at this time.
And, may I ask if, who's is my original judge still Lubet?
Is your what?
My original judge that put me on probation?
That, I don't know who that was. I don't know if they're still in that division, but it'll go back to that division.
Yes, ma'am.
Your Honor, I have 189527, and I also have 174965.
I did that one. I did both of those. I did 17 and the 18. Yeah, I did them all. And the what? I don't know where the on view is. $4,965. I'm missing paperwork on one, it looks like. What's the case number for the on view? Oh, if it's all the same case number? Okay. All right, then that's all of them. You have no bond on your VOPs, and you also have no bond on your capias.
What's the cavius?
The capias is for failing to appear for court.
I have 3 no bonds?
Yes.
Yes, ma'am.
Good luck, sir.
Your Honor, Mr. Frank is mental health.
Hold on. 2021-0002. It's a warrant out of Volusia County. I'll appoint the Public Defender's Office to represent him. Counselor, he has no bond on that.
We'll waive your honor.
All right. Please tell me your name.
Gene Hamilton Jr.
You're here because a warrant was issued for your arrest out of Volusia County, I believe, for failing to appear on a burglary of an unoccupied conveyance and petty theft. Your bond is $2,500. And we'll notify them that you're here. That's it. Yeah, it's $2,500. All right, good luck, sir.
Okay.
The last one that I have is Justin Marino. Did he bond?
I don't have that.
I think he bonded. All right, does anyone have any other business before the court adjourns for the day?
No, Your Honor.
No, Your Honor.
All right, thanks, everyone. Have a good day.